Hi, welcome back. We spent a lot of time talking about wills, what they are, how you do them. I thought for this segment what we'd do is give some thought to what you actually need to prepare if you needed to go and see a lawyer and get a will. And of course, as always, it's far more complicated than you think. So I've got Frank Gianarelli from Armstrong Lawyers to join me. Thank you for joining us, Frank. How are you?
Well, very well, thank you.
That's good. Now, we're sort of focusing on what people need to think about before they see a lawyer.
Yes.
You've got a list of stuff that you'd like people to bring to you before they come. Can you explain what sort of things they would have to think about before coming to see you?
Well, first and foremost, you've got to look at what is individually owned by a testator or will maker, and that means making sure that they don't confuse their individually owned assets with other assets, or non-will assets, as we call them.
I had a client once who had a will,
yes,
and when we delved into it, the only thing he was really bequeathing was a filing cabinet.
And that's very common.
Because of the fact he had family trusts and businesses and everything else. So
that's right.
That's quite important. So anything that's not in your name alone falls into a will, and they need to give thought to that.
Unless something from that other entity, as it were, or held by another entity, is actually paid into the estate.
Okay, so complex.
Yes, it is.
Which is why we need a lawyer to do a will.
Indeed.
Yeah.
Horses for courses.
So what else do they need to think about?
Well, they need to know what those other entities control, what assets those other entities control. That is, if it's superannuation, obviously that's a given. It controls their superannuation. Perhaps their insurance policy is allied to that particular.
So superannuation does not fall into a will unless
it's actually directed to
the beneficiary has been set up so that it does.
Exactly.
And most people don't set up beneficiaries in wills, so you can be assured that in most cases your super isn't covered by your will unless you make sure it is.
Exactly, and that's why you can have a binding death benefit nomination, which can give an asset or the super proceeds directly to a beneficiary outside the will.
All right. Now, when somebody dies, what immediately happens to the assets of the estate?
Well, the assets of the estates are frozen until probate of the will. Now, we don't necessarily always have to get probate, but where there's land involved, there's always probate. Okay. So probate is the actual proving of the will.
Now, the executor can okay expenses sort of semi-immediately. One of those would be funerals.
Funeral expenses can come out immediately. There's an arrangement with banks these days and other financial institutions that you can pay the funeral expense immediately out of an account, and that isn't frozen. Okay. But that's an exception to the rule.
We were speaking before about funeral insurance and what a waste of money I thought it was.
Yes, well that's right, because you can access funeral monies quite easily.
Okay. Now, in looking at this, the fact that assets are frozen, if somebody is trying to organise their will, they need to give some thought to what their surviving family is going to live on while the estate is being proved.
Exactly, and that's where the, say, a side insurance policy going directly to the spouse can be of enormous value.
Outside of super.
Outside of super, and the insurance proceeds from that can be paid immediately upon proof of death, which can be a death certificate or a funeral notice even, directly to that spouse, and that spouse then can use that money wisely until the assets of the estate as such are unfrozen. Another way of doing it is joint accounts. We've said that. We've said earlier, if it's not in your name, it doesn't fall into the will. Joint assets fall into that class as well. So with a jointly owned asset, whether it's a bank account or even a property, death actually survives too.
Survives, yeah. So the person who survives the death owns it.
Indeed, and not to be confused with a tenant in common position, where you can have either as a tenant in common in equal shares or unequal shares, and that particular share, of course, goes via your will.
So what we're actually learning is even the way you own your house is important.
The interest holding is critical as to what your title says, and that's why it's important to bring in the certificate of title so we can verify exactly what that interest is.
Okay, another thing they need to think about is who might execute the will for them.
Yes, well, the execution of the will can be done obviously by the will maker, him or herself. It can be done by direction. In certain situations, the execution clause has to be tailored.
Okay, so what we're really saying is the first thing they need to do is decide who as a person.
Yes.
And picking your father might be a poor choice. Why would that be?
Well, the executors, the age factor has to be looked at. Now, if you're going to pick your father, it's not necessarily a wise move because, on balance, he may not be around. Statistically, yeah. He may not be around.
Absolutely. So elder brothers fall in the same sort of thing.
Same category. The older you are, the closer you are to.
Okay, so what happens? We pick an elder brother because he's a lovely bloke.
Yes.
And we trust him explicitly.
Yes.
And then he gets hit by a flaming oil truck the day before us.
Right. Well, there's your substitute executors that have to be actually put in the will.
Okay, now if you failed to do that?
If you fail to do that, then you've got to go to letters of administration.
Wouldn't the brother's executor execute your will?
Only if that brother's executor actually proves that will.
Okay.
So there has to be a chain of representation, not always the case.
Okay, so in other words, what we're really saying is you need to think about an executor and an alternate.
Absolutely, a substitute.
Yeah.
And make sure that you get perhaps even an independent executor to balance the ledger a bit.
Okay, so we spoke about having assets outside of the will.
That's right.
So that people can survive. How long does it generally take to get a will from, say, death to distribution?
Well, it depends on the asset size of the estate and so on.
Just the average?
Oh, the average shouldn't take more than from go to woe, perhaps a couple of months at outset.
So, Frank, 2 months seems like a long time. Probably doesn't for you because you deal with lots of wills. But this is back to our point. Really, you need to provide 2 months' worth of income to people who depend on you.
Exactly. The spouse has got to have something to utilise and pay the bills. The bills are still going to come in, and you can't necessarily stall the creditors.
No. Okay. Now we've got into some really heavy stuff so far. One of the most obvious things is who do you actually want to benefit from the will?
Exactly. Who are the beneficiaries?
Yeah. Okay, now beneficiaries are difficult because you might have a son and a daughter and you might decide that your son's already had too much money.
Yes.
So, and there's situations where people can contest wills.
That's right.
And that would add to the 2 months.
Yes. Yes. You've got to wait 6 months from the grant of probate to be sure.
That's right.
Because they've got that right. Yeah.
And it's easy to it's easy to contest a will because that's paid for by the estate.
Yes. Usually the costs come out of the estate.
Yeah. So if you're a disgruntled son, daughter, cousin, uncle, niece, hey, then contest the will because why not? And many times the estate will say, "Here's some money, go away." Is this the case?
Exactly. Yes. Look, in a lot of cases, even though there's no merit in the claim. Just to get them out of their hair, they'll have an amount that's offered, and sometimes that amount's good enough.
Yeah. So what we're saying here is that even though it's your money and it's your money, Ralph.
Yes.
Whatever you decide will be questioned and reviewed by the law.
Yes.
So if you really want your wishes to be met, you have to ensure that they're equitable across everyone who feels they have a right to the estate.
That's right. The question or the test is there's a responsibility to make provision for certain people. And if there's a responsibility by the will maker to make provision for a particular claimant and the will maker doesn't do so, then he's leaving himself open to a claim.
Yeah. So let's say then, let's give a typical one. We've got a son and a daughter and a son who's a black sheep and he doesn't particularly like his siblings and hasn't seen his parents for ages. The parents say, bugger him, he's not getting any money. And he says, well, I think I should. And successfully gains money out of the estate. How would the person drafting the will sort of ensure that the other siblings, the one he got on with, got the money? There's a drafting. We can't ignore the black sheep, can we? I guess
that's exactly the point. You can't ignore the black sheep, and there's not really much you can do if the court exercises its discretion to actually award something to that black sheep.
Yeah.
And invariably, they're not going to go overboard. The court's not going to go overboard on that level, but they're not going to ignore.
It's a delay, anyway.
It's a delay.
Yeah. Okay, so even in the obvious picking beneficiaries, you have to do it with care. You have to do it in a way that will stand up to rigour later.
Yes, you have to.
Yeah.
And sometimes you can do that by putting in a few reasons as to why you're leaving people out. It's a bit of a two-edged sword, but sometimes it can work, and especially if it's there's reference to it, but there's no actual text to it, and you've got to go to another document outside the will. that can sometimes be a device in litigation.
Or the black sheep, I gave the black sheep $200,000 ages ago, he's had his bit.
Yes, well it brings me to the equalisation clause that can be put in a will to actually state that if there has been money given during a person's lifetime, then that should be brought into what we call hodgepot, which is just a grossing up of the estate.
I love these terms.
Yes, it's a great little term. So that's the way the whole aspect of it has to be equalised in that way.
Okay. Now, some lovely terms. Can you describe to us what a bequest is?
Yes.
What a legacy is?
Yes.
And what a remainder is?
Yes, a bequest is something by way of a chattel, let's say. I bequeath my motor car.
Yep.
A legacy talks in terms of money, monetary sum, like I bequeath, I give, usually give rather than any other term.
Yep.
I give the sum of $5,000 to my son, Joe. The remainder aspect is everything other than the legacies and the bequests taken off the top.
Okay, so now bequests are a nuisance.
Yes.
Right, this is where you say, my ring I'm giving to my daughter, and my car I'm giving to my son, and that dresser I'm giving to my cousin, and this wonderful table here I'm giving to so-and-so.
Yes.
And then you live for ages, the table falls apart, the car gets broken.
It clutters up the will completely, and it's needlessly put in a will. A lot of people think that it's a great idea, but for the very reasons you just outlined, there is no way in the wide world that I'd be doing that. You could have a separate letter of chattels aside that could be done, but that has to be done at the time of the will as well. So the same sort of problems can arise anyway, but at least it doesn't clutter up the will.
Okay, so the way to deal with it, how would you deal with it? Would you give your ring to your daughter now?
Yes, well, a lot of people
borrow it.
Well, a lot of people put a little note under the item, and you know, that's unless there's a fight. Most people are pretty amenable to adhering to those sorts of devices.
Okay, now the whole point of this program is that viewers should be able to create their financial plans without the aid of advice. And yet we, being in the advice professions, understand that when advisors speak to each other, the outcomes are always better. Can you give us an example of that?
Well, yeah, you can integrate the knowledge of a financial planner, accountant and so on, that can, you know, they know the background, they know the history of the particular person, and you can actually get the will and whatever other aspects have to be done going a lot faster if you can have a team effort with a financial planner, accountant and so on. That way you ensure that you've got all the background knowledge, not relying on the client to come in and provide you with it, because it's already been provided as by diagram or plan or whatever you like to call it. It can only be done, in my opinion, certainly with the tax situation as well. The advice of an accountant can be critical, and no one wants to pay tax. So it has to be a combination of lawyer, financial planner and accountant, as far as I'm concerned.
Lovely. Thank you very much for your time and your knowledge, Frank. It's been really good.
No, not at all. You're most welcome.
Good.
Thank you.
Look, I'm sure you'll find this segment really interesting. Frank is a great source of knowledge and he shared it very generously with us. Okay, so what have we learnt? We've learnt that there's a lot of stuff to consider. The stuff that you think is easy, who shall I give my money to, isn't as easy as you might think it is. The stuff that also you might think of easy is what money am I going to give away, isn't easy because you actually might loan it. It might be owned through an entity. So it is an area where you need to give a fair bit of thought. But look, what we've tried to do is give you the information. The other overarching issue here that we might have learned is that when other advisors speak to each other, the outcomes are always better. Okay, we'll see you after the break. We'll look forward to seeing you then.